Hi, everyone. Thanks for joining the webinar, the Fiscal Year 2017 BJA Adult Drug Court Grant. I'm Lauren Van Schilfgaard with the Tribal Law and Policy Institute. Just a couple of housekeeping issues. This is a webinar. You have options to the right of your screen. If ever you have any questions, please feel free to just type them in. We will likely address all of the questions at the end of the webinar, but feel free to type them in as they come to you. There are a couple handouts for this webinar. I've included all of the slides that we will be going through today. I encourage you to save those for later, pull them up, skip ahead, go back in case you missed anything, and share them with anyone who wasn't able to join you on this webinar. I've also attached the grant application that we'll be referencing throughout the webinar, as well as a couple of other resources, the State Drug Court Coordinator's contact information, I'll be mentioning that later, and the tribal key components. At this point, I think we should dive right in. Keep in mind that this webinar is being recorded. I will post the recording in a couple of days once we've had a chance to convert it, as well as all of these materials on wellnesscourts.org. So as I mentioned, I'm Lauren. I spearhead our Tribal Healing to Wellness Court Training and Technical Assistance Initiative. We provide a number of resources for tribes, including on-site technical assistance, off-site. I maintain wellnesscourts.org that has a host of resources, including our publications and webinars such as this. We provide trainings, national and regional, including the enhancement training in September. I hope you'll be able to join us. Also on this webinar is Tim Jeffries. Tim, are you able to say hello?
Yes, good afternoon or good morning, depending on where you are. I'm Tim Jeffries with the Bureau of Justice Assistance. I'm a Senior Policy Advisor for Drug Policy and the Drug Policy Programs. I'm more than happy to join Tribal Law and Policy Institute as our training and technical assistance provider to deliver these resources to you regarding our funding opportunities and to really dialogue the differences between the different federal grants that we offer. We're excited to partner with Tribal Law and Policy Institute, and I believe I will be on board throughout the entire presentation to address any specific questions about the solicitations and how do you know which one you want to apply for. Should you have questions, as Lauren mentioned, throughout the session, if you jot them down towards the end, if it's something that I need to address, I'll be more than willing to help.
Thanks, Tim. And we were also hoping Mark Klein would be able to join us. Mark, I don't know if you're on the line. No, I don't think so. He is another policy advisor with BJA and another great resource should you have any questions. Here's his contact information regardless. But meanwhile, let's dive right in. So the purpose of this webinar is to really focus in on the BJA Adult Drug Court Grant. This is one of several funding opportunities available for tribes, the other big one being CTAS that I'll mention just briefly. But otherwise, this is a big grant and it's a little complicated, which is why we're devoting an entire webinar to help go through it. So here's a little overview of where we're headed. We're going to take the grant components one by one. This may seem a little redundant going over the entire solicitation. This is definitely work that you can be doing on your own. However, there's a couple of changes and some subtle differences between this solicitation and CTAS. And so those are what I want to highlight today, as well as arm you and get you ready so that you can submit the best application possible under both of these grants. So here we go. CTAS. We had a webinar last month on this solicitation right when it was released, but the big crazy news this year is that both CTAS and this BJA Drug Court Grant are due on the same day, February 28th. So whatever your schedule outline for writing these grants, they can conveniently overlap. They have generally been in the same time frame. It's sort of a coincidence that it's on the same day this year, but not so much of a coincidence. The Department of Justice was really vigilant this year about getting the solicitations out, particularly before the administrations switched. The switch in administration does not, at least this year, directly impact the funding. The funding was already appropriated by Congress, but DOJ was really good about getting the solicitations out to us so that we would have them and can count on applying to them. Both CTAS and BJA Adult Drug Court have given us the maximum amount of time from the day they release the solicitation to the due date in order to complete our applications. But nevertheless, February 28th is screaming towards us. So if you have not started thinking about how you're going to put together your application, now is a great time to start. I'll leave the rest of CTAS for that other webinar. I've posted the slides, but just so you know, there's 2 purpose areas under CTAS that are ripe for healing to wellness court applications. The big one is purpose area 3. That's for all tribal justice system and substance abuse projects. Anything to do with your tribal court, treatment, intervention, or a healing to wellness court can go under purpose area 3. That's where we recommend your adult and family applications go. And then purpose area 8 is devoted just to juvenile healing wellness courts. It's 3rd year that it's been out, and it's a great resource if you've been thinking about applying to a juvenile drug court. That's the one you want. But I'll leave the rest for another day. We are focusing on BJA Adult Drug Court. So here we go. Where do you find the RFP? You can find it here on this webinar. It's one of the handouts. It's also online. I posted it on wellnesscourts.org. Let's see if I can do this. Here, under federal funding agencies or funding announcements, you can find it posted there. It's also on bja.gov under their funding tab. Here it is right here. It'll be posted there for at least a year. You can find old solicitations as well. This year's is a little bit different, but you can find them both there. In the grant, there are actually 3 categories in this grant, but I will only be focusing on the first 2 because those are the 2 under which tribes are eligible to apply. The 3rd category is a statewide application. It's meant for statewide coordinators to apply to administer an entire drug court administration for the entire state. I have included in the handouts, as I mentioned, these statewide drug court coordinators contacts. I encourage you to open that up and find the contact for your state. It's possible that your state offers resources, technical assistance, trainings for the state, and potentially even funding that may be eligible and open to tribes. If nothing else, they are a great resource to help connect you to other drug courts in the area. They are literally waiting by the phone, waiting to help you, so please reach out to them. Back to an implementation and enhancement. As the name suggests, implementation is meant for drug courts that are getting ready to start to implement their first drug court, and enhancement are for drug courts that are already operational. The purpose of this entire grant is very, very specific. It is for drug courts that meet these 4 bullet points. They're using evidence-based treatment, they conduct mandatory drug testing, they use sanctions and incentives, and they offer transitional services in a judicially supervised court setting that has jurisdiction over its substance abusing offenders. If you are designing a program that you don't think falls into these categories, this might not be the application for you. The nice thing is that all of these are based in the key components and the drug court standards that I'll be talking about in a little bit. These are all research-based, meaning that they have studied drug courts in the past and pulled out the practices that have yielded the best outcomes. And so these are a great idea. It's not some wonky thing that was invented in some lab, not based in reality. These are based very much in reality. But the scope is narrow. If your drug court doesn't meet this, you're likely not going to get funding. So again, I just am highlighting what is a drug court. They have defined it for us, which is very nice. This is the opposite of an open-ended, write anything that comes to your mind, stream of consciousness. This is very, very bullet points of here's what you need to include. So this is a court program. This is not something that behavioral health or social services is doing on their own, separate. This is considered a court. Ideally, it is recognized as a court, a member of your judiciary. But if it's not formally recognized, that's okay. Part of your grant application potentially could be instituting it as a court program. It's a multidisciplinary team, meaning we're pooling resources from the court, from treatment, from social services, behavioral health, community supervision, etc. Responding to offenders, offenses. This means this is a criminal adult drug court. All of our participants have been arrested or convicted for some criminal offense. And they have treatment needs because they have a substance use disorder. These are not participants who we think could benefit from treatment as a preventative measure. We couldn't fit them anywhere else. They have all of these other needs, so wouldn't it be great if this was an umbrella and we'll just throw substance use treatment at them because it wouldn't hurt? No. These are participants that have been shown to have a substance use disorder because we are putting a lot of treatment needs, and it's been shown that treatment only works if they have a substance use disorder. If they don't, we could potentially be doing harm. Okay, amounts and lengths of the award. This is really exciting. In the past 2 years, we have seen huge bumps in the amount of money that's being offered under these awards. First, for implementation, this used to be $350,000 for 36 months. It's up to $400,000, which is incredible. Even better, for enhancement, this used to be only $300,000, and it used to only be for 2 years. It's now been bumped up to $400,000 for 36 months. So these are nice, big awards that you can do a lot of program development and enhancement under. Really exciting. The other nice thing about this grant solicitation is it gives a lot of awards out. You can expect up to 40. Under OJJDP and SAMHSA, the two other major entities that ever offer drug court funding, you're only seeing 10, 15 awards. They're providing a lot under this one.
Hey, Lauren, can I just jump in on this slide? Please. I don't know if you're going to cover this at a different area, but I just wanted to mention the importance of why we increased this amount to $400,000 for the implementation and the enhancement grants. And that's primarily because we've had a lot of listening sessions and heard from the field that said we could benefit from additional dollars on community reintegration. And we also identified a huge need for more community integration funding, especially as it pertains to rural communities, through the introduction of teleservices and telehealth. So we really wanted to make sure that we provided money for transitional care back into the community, also for opportunities for jurisdictions to apply for a community reintegration specialist or anyone that can assist through transitional housing, temporary housing spaces, job reunification, job placement, even any type of ancillary services that go along with that. So please be in mind that this additional funding can help with a myriad of different resources that were deemed to be missing or lacked in the community.
So thank you, Tim. That's really interesting. What I heard there is community integration, and so that goes a little, it includes the drug court, but it goes above and beyond the drug court, right? When you're offering housing, that's going to benefit your drug court participants, but it can potentially also benefit community members who are not in the drug court. So that's really interesting. I would highlight that in my notes if you're taking notes right now, that community integration is a priority for this grant, offering things like telemedicine or telecourt services. And aftercare is also what I heard, transitional care, someone on your drug court team that can assist participants after they've graduated, services that we can include in our drug court but are also going to be part of our overall services. Thank you, Tim. So diving back down into the numbers, how do tribes fare with this grant? Pretty decent. A handful, we expect 2 to 3 tribes to receive grants every year under this solicitation. Not a lot, but considering proportionally, they do pretty well. In fiscal year 2015, we saw 6 tribes get awarded, which was fantastic. Last year, there were 2. If ever you are curious about seeing a solicitation, you can request that the tribe share their grant narrative. It's up to them if they want to share. You can go on to the BJA.gov website and see who was awarded in years past. You can also request just to see a sample of a successful grant application, just to give you an idea. So now we're going to dive into the content of the solicitation. In 2014, the National Association of Drug Court Professionals issued these drug court standards. They are different than what was in the past considered the foundation, which were the key components. The key components are considered aspirational components that your drug court should have. The standards, however, are research-based floor of what your drug court should have. Now that we've had time to research drug courts, see them in action for 10, 15, 20 years, so we have a little bit longer data to look at of how do people actually fare in drug court when we offer drug testing, or when the judge has been sitting on the bench for a number of years, or when the judge spends longer than 5 minutes each hearing with each participant. What are the practices that produce better outcomes than others? Well, here we go. We have the standards. The bad news is that unfortunately no tribal healing to wellness courts were included in any of these studies. Nevertheless, they include some really important tips that I think we should consider in our own healing to wellness courts, and for purposes of this solicitation, we have to consider them. So what they want to see in your application is anytime you are suggesting to do a particular practice, make a citation of how that practice coincides with the standards. That means that you need to be familiar with the standards. The good thing is that even though these are kind of meaty documents, there are only 10 standards that you need to be looking at, so it's doable. They're broken up pretty easily. The other good news is that next week, exactly 7 days from now, I'll be doing another webinar devoted solely to these standards and how they relate to the key components with this solicitation in mind. So if you're feeling really uneasy about the standards, you haven't ever seen them, you don't know what they are, feel free to tune in next week. Similarly, that webinar is going to be recorded and posted along with just the slides, so that'll be another resource available to you. Okay. Here's the grant, the implementation and enhancement. We are going to approach both of these in tandem, going through the application itself, but keep in mind you're only going to be applying for one or the other. So implementation. This is for tribes that are in the planning process, but just about ready to implement. So if you are just starting to think about a drug court, you might not quite be ready for implementation. There's still a lot of detail they want you to have already figured out in your application. So keep that in mind. This is, you've already planned, you're ready to implement. They have listed very specific things that you can use the funding for. Nevertheless, each of these categories is still pretty broad, such as court operations and services. This can be, you can use funding to fund your coordinator or your judge's time on the Healing to Wellness Court. Participant supervision, that means probation or your case manager or any of their services such as your drug testing materials. And then they list a lot of examples under the recovery support services, which relates to what Tim was talking about as far as the community integration, aftercare, housing. They also list education, civil legal assistance, which is really interesting because under a lot of DOJ grants, we see limitations on using civil legal assistance, primary and mental health care. You can be really creative about what you currently are lacking in your community that you can fund under this grant. Enhancement. This is different than an implementation. You are already up and running. You already have participants under your belt. No one needs to necessarily have graduated yet, but you've been in operation for 1 year. So that means it's been from 1 year from February 28th, you admitted a participant. Here they are 5 things that you can use this funding for. 1 is incorporate any of the 10 NADCP standards. That's pretty broad. There's a pretty big menu to choose from in there. Scale up. I have bolded this. You can't really tell on this slide, but this is mentioned throughout the application. One of the big things they want to see under both implementation and enhancement is you're using this funding to increase the number of participants that you're currently serving. I'd say pretty much universally in every single study that has ever been conducted on a drug court is that no drug court is currently serving the number of participants that it could. We know, we don't need to see any study, we just know that there are far more individuals in need of drug court than are currently being served. And yet there's this real barrier between the number of individuals coming through the court with a substance use disorder and the number of individuals being just admitted into drug court. So it is a big push by BJA to scale up the capacity of drug courts to serve an increasing number of participants. This is somewhat less relevant for tribal healing to wellness courts, but I would say just anecdotally from what I've seen, it's also true that tribes are serving fewer individuals than they could, than the caseloads suggest that they could. Other options: enhance your ability to collect data and conduct evaluations, expand your case management. I think drug testing is a really popular method to fund just because that's a flat expense that you can't really negotiate around. And expand your services based on any needs assessment. I'd say this is a big one. The underlying needs assessment, you want to be able to draw some connection between what you're proposing to fund and how you identified that as an actual need. It shouldn't be something that you just invent off the top of your head. Wouldn't it be nifty if we had housing? But to say, no, we actually need housing because we have X number of participants who had housing as a barrier and why they couldn't successfully graduate drug court. You must demonstrate that the arrestee population will support this expected capacity. I'd say this is a major point for tribes. If you just don't have the numbers and you are currently serving the capacity that the arrestee population suggests, then proposing that you're going to double or triple the capacity of your wellness court just isn't realistic. And the last place you want to be in is proposing that you're going to be serving 50 healing to wellness court participants a year if your arrestee population is only 25 a year. Stay reasonable so that when you are successfully awarded this grant, you actually have a shot of achieving the objectives that you said that you would. There is a 25% match requirement on this grant. This is not required in CTAS, but have no fear, this can be an in-kind services match or a combination of cash and in-kind, so you can do this. Also keep in mind that it's not 25% to equal an overall budget of $400,000. No, this grant is DOJ is getting ready to write you a $400,000 check, and so your overall budget, if you were to request the full $400,000, would be a total budget of $533,000. So this is just an example of the math, but just keep that in mind. The match is restricted to the same limitations on federal funds. You can see in the solicitation there are a number of asterisks on what you can use this federal funding for, such as for food or for incentives. You can't serve violent offenders. We'll be going over that in a little bit, but just keep that in mind. And don't overmatch. Whatever you suggest that your match is going to be, they're going to hold you to it. So you're just expected to go up to the 25%. Don't commit yourself to more than that, because all you have to commit to yourself is to the 25. Okay, MAT. This is another big section. This was in last year's solicitation, but I'd say this is a growing issue. And so please be sure that you note your acknowledgement of MAT and what the current status of the availability of MAT is in your community. For a while there, drug courts were excluding candidates from their eligibility criteria based on if they were using MAT. It has come out you cannot do that just because someone is currently seeking Suboxone or buprenorphine or some other medication-assisted treatment for their opioid addiction does not mean that you can say, no, we're a abstinence-only drug court. No means no. No, you cannot do that. MAT is considered a treatment, and you cannot deny someone for accessing treatment. However, the solicitation does define what an MAT program is. So if there is a medication-assisted treatment clinic in your community that you think is not meeting these certain conditions, such as there is not a licensed clinician that is supervising the administration of this medication, it's possible then that you could say, yes, we acknowledge the importance of MAT, but currently that is being extremely abused in our community. I caution that you're going to want to be able to back this up. Just because you don't like MAT or you don't like the doctor is not a good enough reason to deny this. Before you go down this road, I encourage you to maybe reach out to DOJ and get their thoughts on this. But keep in mind, there is a major push to encourage access to MAT. If MAT is not available in your community, you just need to note that, particularly if you're in a very rural community, but hopefully it is. So as I mentioned, violent offender prohibition. This has been part of BJA drug court funding for a long time. It's attached to the funding appropriation, so this is Congress doing this. Basically says that if an offender has been prosecuted for a violent offense, punishable for a year or more, and they define violence as your standard violence involving may or may not involve a weapon, then you cannot use BJA drug court funding to serve them. If you have prioritized serving violent offenders, which I know some tribal healing to wellness courts have, you can still apply for this funding, but you just need to ensure that you bifurcate your funds and ensure that none of the BJA funds go to serving those offenders. You will have to have very diligent accounting to be able to do that, but it definitely can be done. I have a couple of notes here. The federal definition of violent offense includes that they have been punished, they've been sentenced to a year plus in jail. If the underlying violent offense was a tribal court conviction and the tribe is not exercising Tribal Law and Order Act enhanced sentencing, then they necessarily could not have been sentenced to a year or more in jail, even if it was otherwise a violent offense that would not satisfy this violent offender prohibition. Just some fancy legalese there. You'll want to check what the underlying violent offense was. Also, under CTAS, there is no violent offender prohibition. There is for the juvenile one under Purpose Area 8 because it's similar drug court money, but the Purpose Area 3 is not. And so if you really want to prioritize serving violent offenders, then I encourage you to apply under CTAS Purpose Area 8. Or if you are applying for a veterans treatment court, they make an exception for the violent offender prohibition. So another consideration to keep in mind. Okay, interestingly, there is now when you're applying for drug court funding, either under implementation or enhancement, they have required team members that they want to be on the team. I happen to agree. I think these are all great ideas. If for some reason you don't have one of these individuals currently committed, I encourage you to apply anyways, but include in your application what the circumstances are and how you're going to overcome their absence. So we want the judge. I think that's a pretty critical one. The prosecutor, the defense counselor, I imagine being the one that potentially might pose some issues for tribes. Here we want to ensure that there is both procedural fairness as well as the perception of fairness in due process. So there are ways that we can accommodate the lack of a defense counselor, but ideally we have a defense counselor, our treatment provider, our researcher, evaluator, or data management specialist. In an ideal world, this is a standalone position, and I encourage you to think of it like that. But if funding simply won't allow, this is often a role that's provided by the coordinator. And then community supervision, which is probation. And then again, coordinator, this role is often combined with the case manager. But again, I encourage you to think of the coordinator as a standalone position distinct from the case manager and the researcher. Okay, application. We're getting into the meat of the application now. 4 major parts. This is very similar to CTAS. So if you are applying to CTAS, you can at least rest easy that you're doing the same type of work under both of these solicitations, which is nice. Note that the project abstract is a distinct document, does not go against your 20-page limitation. The same goes for the time task plan. The task plan is a great opportunity to expand on your goals and objectives that you couldn't fit into your 20 pages. So if you want to get into some nice, juicy details, your task plan is where you can do it. If you don't have those juicy details yet, that's okay. You still need to submit a task plan that at least identifies the goals and objectives from your program narrative, along with where in the 3 years you're going to be accomplishing those. And as always, make sure your budget matches up with your narrative. In the frenzy of writing a grant, things change, you go back and forth, you have 1,000 meetings, things blur together. Make sure you go back and check that what you're requesting in your budget is what you're requesting in your narrative. Sounds basic, but once you get into the frenzy of it, those start to change. Okay, so now we're going to go through these one by one. The abstract sounds easy. It's 1 page. You're just summarizing what's in your narrative, but they have 11 bullets of things that they specifically want you to address. So make sure that you address those one by one. They're pretty straightforward. It's not going to be complicated. I just want to make sure that you're organized when you're doing this. You need to describe your court. They want to know specific things like, is this urban or rural? Are you pre or post adjudication? That means when people enter your healing to wellness court, have they already been convicted, or is the charge being deferred upon successful graduation? Both are fine. The advantage of pre-adjudication means you have a nice carrot to offer your candidates for coming into healing to wellness court. They'll avoid conviction. But the advantage of post-adjudication is now if they are terminated for any reason, you don't need to try a stale 8-month-old case. So we see both, pros and cons with both, but you'll need to pick one. We want the contact information of the judge. This is critical because the judge is often considered the real cornerstone for our wellness courts, so we want to know who they are and that they've committed. How much money are you asking for? There we go, number of participants. How many are you currently serving if you're an enhancement grantee or applicant? And how many are you proposing to serve? And then the total number that you're expected to serve over the 3-life grant. This is kind of a funny way to think about it because otherwise this is not how we would approach data management, but consider how many participants, regardless of whether they've graduated, terminated, or are currently still in your drug court, you expect to have over the 3 years.
Can I jump in here for 1 quick second? I think this is another good opportunity to reflect on the data that we see for the existing cohorts.
Heck yeah.
So we've asked a lot of these questions, and Lauren did mention that it is kind of confusing the way we ask the capacity in so many different ways, is because what we've seen when we do performance measure review is that a lot of these applications that turn into awards, they're serving way less clients than they project. So rather than pull the funding, the intent is never for us to pull the actual grant monies that you're awarded if you're under capacity, but to go in there and look at ways to provide training and technical assistance to help build capacity to the numbers that you were expected to serve. So this is why when we ask the amount of funding based on the capacity, we really want to know exactly how many numbers of clients you think you can serve within that grant period and how many you think you can serve consistently over that year. And then trust me, our data folks will look at that. If you were awarded, if you are fortunate enough to get an award, we look at that to see why you're not meeting your numbers for those jurisdictions that aren't, and then we will provide assistance regarding that. So please be mindful when you're looking at exactly how many clients you can serve, not to overstate it, but to state it realistically based on the statement of the problem section and what you've seen in your arrestee population.
Thank you, Tim. So going right through, this is still continuing on the project abstract. They want to have you note that you're using a risk needs assessment for your target population, that you're going after the candidates that are most in need of supervision and most in need of substance use treatment. They want you to note which standards that you'll be referencing in your application. So this obviously you can't complete until after you write your narrative. And they also want you to describe your data collection mechanism. Basically, what court program are you using to track data, even if it's just Excel. They ask if you're in an empowerment zone or renewal community. These are specific federal programs. You'll know if you aren't or if you are, but they detailed this in the solicitation, so don't worry about it if you don't know what I'm talking about. Are you applying for other federal funding? And have you previously received drug court funding or participated in the training that I'll mention in just a bit? There is a template that they want you to use for this project abstract. If you have applied for OJP or Office of Justice Programs funding in the last year, then you're familiar with this template. It's the same for all OJP applications. Here's just a snapshot of that template. Note that it does not include prompts for those 11 bullets. This is just a general template, and so you still need to reference those 11 bullets. So don't think you're off the hook just because the abstract template doesn't have those. Narrative. So here are the percentage breakdowns for each section. We encourage you to look at these percentages as a tip on how many pages you should allocate to each section. But even though I say that, in a little bit I'm going to kind of contradict myself because it depends on whether you're an implementation or an enhancement applicant for where a lot of the detail is going to be included in your application. So we'll go through these just one by one real quick here. Statement of the problem for implementation. You do not yet have a drug court, so you are just laying the land for why you want a drug court. You want the nature and scope of substance use. As much as you possibly can, having arrestee information, having stats from your treatment provider in your community, any kind of hard numbers to show the severity of substance use in your community will help. National data is good. National data from tribes generally is good, but nothing beats the local data for why you need a drug court. Problems with your current response, why the regular adversarial model is just not working, or why the regular treatment responses are not working. Again, capacity goal, as Tim mentioned. You want to be ambitious, you want to serve more participants than you currently are, which is none, but don't oversell yourself. Be realistic. Okay, enhancement. This is very different than the implementation. They want lots of detail of what you're doing here. So I would say you'll be devoting a few more pages than the percentage amount in order to get all of this detail here. They want you to provide a comprehensive breakdown of what your drug court currently looks like. You're going to be referencing the key components in the standards, but I recommend addressing these in order as they appeared as sort of a system walkthrough. How does a participant go from the initial arrest to graduation? What are all the different aspects of the drug court that they see through that? I'll be going over this in more detail next week, but these are all categories that must be addressed within the statement of the problem. In addition, they want to know how you're targeting high risk, high need. This means what screening and assessment tool are you using? If you're not, then that is likely a category under which you're going to be applying for funding to integrate into your drug court. What are your treatment interventions looking like? And how were they selected? Again, there are not very many interventions that are based in Indian country. There are a few. Maybe you're using those. Maybe you're using others. How did you come to select those? Project design. So now it sort of flips between where the meaty details are going to, based on whether you're implementation or enhancement. Either way, we want to see that candidates are going from candidates to participants as quickly as possible. They are getting into drug court and they are getting into treatment within days or weeks. If that's not the case, then maybe you want to discuss why you need funding and how you're going to decrease that amount of time. For example, they say in some jurisdictions they need to go to jail for 6 weeks to think about what they did and then start drug court. We don't like to see that. Sometimes that's statutorily mandated. It's required under the law and there's nothing you can do about it, but hopefully your tribe has not done that. Fees are allowed in drug court, but in some drug courts, the fees were so large that candidates or participants that had otherwise satisfied all of the other requirements couldn't graduate because they owed the drug court like $3,000. We don't like to see that, obviously. Someone should not be withheld graduation just because they can't afford it. So note that if you will be requiring fees, that it's not going to prevent graduation. Don't be afraid of fees, though. It's a good way to fund your drug court, particularly things like incentives and sanctions. So I've seen tribes charge $10 or $20 a month as sort of a monetary sign of commitment. It's enough money to make you think about it, but not enough to withhold graduation. You must permit access to MAT. You must be aware of racial disparities. This is an entire standard in the NADCP Drug Court Standards. This is less relevant for most healing to wellness courts because our entire population necessarily is going to be Indian based on jurisdiction. But regardless, keep this in mind because it's a standard that they want to show that regardless of race, people are getting access to your drug court and or are not being punished differently because of their race, such as for sanctions. Okay, for implementation. Now, this is where we want to see all of the details for your drug court. Here are all the different categories that you need to go through one by one. So that's why this grant is intended for tribes that have done significant planning because these are details that you've already hammered out. If they're not, maybe you want to just note that these are things that you're thinking about. You've looked at the key components and standards for what they say about things like judicial supervision. And so while you have not completely designed how your hearings are going to look, you do know that it's important that the judge spend at least 3 minutes with each participant during a hearing and that you conduct hearings at least twice a month. So that can be sufficient for your application if you haven't quite gotten there yet. But ideally, you have considered these as a team before you submit your application. Enhancement. So these are going to be your project design. This is what you're boosting your drug court to the next level. So we still want detail here, but keep in mind for your grant application, you just spent 7 pages detailing all the different things that you're currently doing. As I mentioned before, there's only 5 different areas that you can apply for funding under, but one of which is incorporating all of the 10 different standards. So you have options. You need to pick which one, but you also need to detail your drug testing process, your hearings, all of these other little things that are based in the standards. You just need to ensure that, okay, if you're applying to bring in new parenting services for your participants, awesome, we love it, but let's also make sure that you're meeting the basic standards that we want you to meet, such as your evidence-based treatment interventions. If you ever have any questions about these, I'm blowing through them really quickly. I want to make sure we stay under the hour. Feel free to email me, but also keep in mind I'll be going over these next week. Next section are capabilities and competencies. What makes us as a multidisciplinary team able to do what we say we're going to do, as well as manage this grant? The first question is, have you participated in the Drug Court Planning Initiative? This is a training opportunity offered by the National Drug Court Institute. If you are just in the planning stages, I highly encourage you to reach out to them. This might be a good possibility. It's a really intensive 3-day training. They come to you, they work with your entire team, and get you well positioned to implement your drug court. Because of that, BJA gives a priority to those who have already participated in that training for this grant. It's not a requirement. If you haven't participated in that, you are still warmly invited to apply for the implementation, but it's just something to consider. You can also apply for it even after you apply for this grant, so keep it on your radar. They want you to identify each of your team members. Ideally, this includes all of those required team members that I mentioned earlier, but also some others. Maybe you also include a community member, a cultural advisor, a representative from behavioral health, social services, child welfare, housing. These are all great individuals to include. Describe your communication strategies. This goes towards key components 1 and 10. Big picture, how are you going to handle disputes among team members? Smaller logistical, how are team members going to coordinate all of their information each week in a staffing? Are they going to use a database? Are they going to submit all of their information to the coordinator who's going to consolidate it? What's that going to look like? Does law enforcement and probation, this is like kind of a unique pull-out, but we always have seen really great results when police officers are part of the team. So are they going to be part of your team? In some jurisdictions, the police love drug court. They love being a part of it and are real leaders on the team. In other jurisdictions, they are really hesitant. They see it as some of a soft on crime, and they kind of have to be dragged to the table. So where do you lie? It is what it is, but ideally they are a receptive member to your team. Then describe your treatment. For enhancement, we similarly want to know who your critical personnel are, and then just basic organizational capabilities. Who's going to be spearheading this grant? Ideally, you'll have a coordinator that's in charge of this, but if not, is it the court clerk? Is it the judge? What does this look like? Data collection. More and more, this is becoming a focus for these drug court grants as well as CTAS, and that's because there's a real correlation between the better data collection practices of a drug court and the ability to enhance that drug court to the next level, because you don't know where you're going if you don't know what you're currently doing. Data collection can be a real challenge, particularly if your tribal court doesn't have an overall case management system. If they do, the ideal system will integrate your drug court data collection with the overall court case management, but they can be separate entities. That's okay. We want something that will allow all of the different team members to input data. That way the treatment provider can input, yes, participants A, B, and C all attended treatment this week. They all showed up on time. Probation can input that they all met their checks, that they all met their drug testing appointments. The case manager can check that they all came to their appointments with the case manager and met with housing or education or vocational training. All of those little meetings and data inputs that happen every day, we want to capture all of those. We also want bigger picture for our overall drug court. This can get really deep really fast, which is why it's so ideal to have our own data management specialist on our team. But if you don't don't have fear. We, TLPI, are here to help you navigate this, as well as other technical assistance providers from BJA. So we can do it together, but just ensure that you devote the time to prioritize this. Other things that they want to see is just an aftercare plan. So many times after a participant leaves the drug court, whether or not they were terminated or graduated, we sort of cease communication. Good luck, nice having you, bye. We really want to know what happens afterwards. Did they commit another offense? Did they continue attending treatment? What happened? If there's any way we can capture that, that's the ideal, which is why it's ideal to have our system communicate with the overall court management system. Under this solicitation, there are very specific performance measures that you will be expected to provide if you're awarded the grant. You're not expected to supply any of this information as part of the solicitation, but it's just important that you look at it so that you can know, yes, we can provide all of this information if we're awarded this grant. So here are the URLs for these tools. It's a different one for implementation and enhancement, and it's also provided in the solicitation PDF that's on the handouts. Here's a snapshot of what that looks like. So for example, they're going to ask, what is the expected number of participants that you're going to have? And you need to be able to write in that number. So real quick, here are some of the things they're going to ask you about, and it's basically on two levels. One, there's the program level. What services are you providing? Are you providing positive Indian parenting? Do you have group counseling? Do you have individual counseling? What are there housing specialists that people can talk to? What services do you have as a program? And then the participant level, those day-to-day numbers that I was talking about. The other critical thing here is they're going to be asking about recidivism, so they do want to have you be able to track were participants reoffending either during or after their time in drug court. So here's another breakdown of those performance measures. I put these on just so that you can have an idea of what it is you're going to be expected to provide. So these are going to be reports that you will be expected to complete every 6 months for the 3 years that you have the grant. Here's the second slide there. For example, the number of drug court participants, the number who were arrested, the number who weren't arrested, so on and so forth. Other attachments, the time task plan, as I measured, great opportunity to stick in all of the detail that you couldn't fit into your 20 pages. They want an MOU. This is required. They want all of those required team members that they identified to have signed a document that they agree to participate in drug court either currently or will in the future once you're implemented. Ideally, this is the supervisor of each agency, even if a different person is going to be performing the day-to-day activities in the drug court. They would like a letter from your state drug court coordinator. This is not required. So don't freak out if you've never even had contact with your state drug court coordinator. But if you have, it is a nice gesture to show that you've been in communication with the efforts going on statewide. It is required that you attach your policies and procedures manual if you're an enhancement grantee. If your implementation, it's not expected that this document will be completed, but if you do have one, it can definitely help your application, including as a way to provide some of the detail of your program that you can't fit into your narrative. They also want a tribal authorizing resolution. This is really standard for all BJA applications. You need this for your CTAS application as well. And this is basically saying you have the authority to apply for this grant under the tribe. Other documents that you can and should include, these are more general documents that are required for any BJA application. If you have a grant writer or someone who normally does the submission of your grants under GMS, they'll be very familiar with these. If not, they're all navigable, don't worry. But things like you're not going to be spending money on lobbying with this money. You're not conducting research under this grant. If you are, there's ways you can get around it. But just general documents you need to be aware of that you include. And if you don't include them, they potentially won't even read your application. So make sure you these are all the I's you need to dot before you submit your application. Okay, we're nearing the end. Just some general pros and cons about this grant. I really like it because it's drug court specific. The the RFP writers and the peer reviewers are very familiar with drug courts. You don't need to explain to them what a problem-solving restorative justice drug court is. No, instead, you get to dive right into the details. But it's not tribal specific. You do need to devote some space to talk about your community in a more general fashion. Don't assume that the peer reviewers have any experience with Indian country. You might need to do some very general 101 explanations. The grant does make specific reference to the tribal healing wellness courts. They are aware of the tribal 10 key components, so please rely on the tribal 10 key components. But again, don't expect that your peer reviewer knows what those are. Disadvantage, you have to compete with state drug courts. There's no allocation that a tribe is going to be guaranteed a spot, so we can have a year where no tribes get any of these awards. However, as I mentioned, in the last 5 years, at least one tribe has gotten an award, so it's definitely worth pursuing. There's a violent offender prohibition that kind of stinks if that is your high-risk, high-need population. But as I mentioned earlier, we're getting 40 awards under this grant. There is a lot of money to go around here, and so it is worth pursuing. Here's a resource that they reference and that I highly recommend. It's the National Drug Court Resource Center. There's a lot of materials on here, particularly if you are brand new to the wellness court world. Lots and lots of stuff on here, including the evidence-based links. If you have never heard the term evidence-based, these are things that you want to check out, specifically the middle one, SAMHSA's National Registry. So when you use an intervention, something like positive Indian parenting, they want to know that it's not something that you just made up, but that it's actually been proven to be effective for participants. So these are lists where you can find what those programs are. Keep in mind, not a ton of research has been done in Indian country. There are some interventions that are Indian country based, but not a lot. So you can use something else, but you would want to justify why you're using that and not one of these. Some common mistakes to avoid when applying for your grant is not organizing your grant in a fashion that the peer reviewer can track nicely, not responding to all of the questions. The application is broken down between problem statement and program design, so you want to make sure you're drawing connections between those two. And then inconsistencies. This is more of a problem with CTAS than with this one, but if you're breaking up the writing between multiple people, which can be really nice because this is a big fat application, make sure that it still flows well. You don't want these jarring gaps between different writers. Tips, make sure you check out all of the URLs that are referenced in this solicitation. There are quite a few, but I've identified at least the big ones that you must check out, such as the project abstract template. You must use that. The performance measures, you must reference those. Other ones are more helpful for your information, such as the National Resource Center, but just keep in mind there are URLs that go outside of the solicitation that you're going to be responsible for. And then PDF everything is my closing tip for you. If unsuccessful, you have the right to ask for comments on your application if you weren't funded. So they will send it back to you with what the peer reviews wrote and how they scored. And you can ask for technical assistance to help you in the future. But the best way to get proficient at writing these grants is to serve as a peer reviewer yourself. You have to read 10, 15 applications and you get a quick and dirty dose of what a successful grant looks like and what an unsuccessful grant looks like. So with that, here is my contact information, and I am now going to turn it over to questions and answers. Tim is here with us, so if you have any questions, please feel free to share. You can type them in the box. And if nothing is coming to you at this moment, you can always email us at any time, both Tim and I, including well up until the grant is due and even after. So I'm not seeing any questions. Tim, did you have any closing thoughts?
I don't. I just really want to thank you for all of the content that you have provided. Just thinking back, and I couldn't think of anything that you left out. Certainly we provide a priority for those who attend that drug court planning training, but that doesn't mean that you won't get a grant if you haven't done the planning training. The planning training is intended for folks to really get an idea of what the evidence-based components are that make up a drug court, and have you, the training attendee, embed all of those components into your program. So that's kind of giving you a flavor for that. All the other content that was mentioned, Lauren did a really good job of talking about the things that we see as details that are overlooked generally each year in an application, like the match and the violent offender definition and the performance measures. So just recapping and thinking about all of the stuff, the content that she has given you, will really set you guys up to effectively submit an application, whether it's through CTAS or whether it's through our adult drug court discretionary grant application. And Lauren was really good at saying if you have questions, we do have another 800 phone number that you can contact for generic questions about DUNS number and how to apply and how to seek the correct information. That's very important. And also just recapping that once you guys get started, make sure you give yourself a full week before the application is due to submit. So if there's any problems electronically, we know this is due February 28th. There's a lot of weather conditions that affect that with power outages, and it's hard to reopen an application. I don't want all of the work that you guys have done to go in vain. And each year we have a jurisdiction that comes in and says our power went out at our computer, or we were waiting for one simple signature from one of the entities for the MOU, and we're still waiting, and we can't hold the process up. So once again, please give yourself a full extra week of time to submit that, foreseeing any strange or random issues or things that come up, because they will. So with that, I don't have anything else unless there are any questions that recently popped up, and I'll turn it back over to you, Lauren.
Thank you. Let's see. Don't think I see any questions, but let's get out of here. Thank you so much for joining us. I really appreciate your attention. If any questions come to you later on, please feel free to email us. And with that, I wish you a happy grant writing. Thank you so much for joining us. Take care.